Welcome to Freedom to Learn, the podcast that champions choice in education, defends parental rights, and exposes the harm caused by school unions. I'm Jenny Gentles, Director of Education Freedom and Parental Rights at DFI, the Defense of Freedom Institute in Washington, D.C. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. Those are the 37 words of Title IX's non-discrimination guarantee as signed into law by President Richard Nixon in 1972. My colleague Paul Zimmerman joins Freedom to Learn today to walk us through the Title IX regulatory overreach and whiplash that has occurred under recent administrations. Paul is Policy Counsel for the Defense of Freedom Institute, and he leads our Teacher Union Accountability Project. He previously served as Director of International Affairs at the Federalist Society. Paul will also explain DFI's Respect Title IX Act, a model law that protects women's sports and spaces, restores due process, and defends free speech on campus. The Respect Title IX Act provides a permanent fix to the Title IX regulatory and policy ping-pong. DFI, along with lawyers from Fire and Defending Education, recently held an event on Capitol Hill explaining the Respect Title IX Act. Stay tuned for future events about the model law. Paul Zimmerman, welcome to Freedom to Learn.
Thank you so much for having me, Jenny.
So we're here to have a conversation about Title IX. And when people hear Title IX, they often think, right now, of women's sports. But what did the original 37 words of Title IX's non-discrimination language guarantee?
They say, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance.
Okay, I didn't hear the word sports in there.
Correct. Yeah, absolutely.
Okay, so this was broader. What was the intention when this was passed?
The intention was it was in an era where women and girls were being denied routinely equal educational opportunities, both in higher education, in activities in the K through 12 space. And so members of Congress came together and they passed this law in 1972 that guaranteed equal treatment. It guaranteed that they wouldn't be discriminated against in federally funded programs and activities. And just, I think there may be a misconception that this is just at the higher education level, but it's through all federally funded educational institutions. That includes K through 12 school districts, as well as colleges and universities.
So Title IX's been in place for over half a century. And one thing that is going to be the focus of our conversation is the regulatory whiplash or the policy ping pong that has happened more in recent years. People understood what Title IX meant initially, but we've had a lot of back and forth in its interpretation in recent years. What sort of kicked off that regulatory whiplash?
Yeah, and just to set the table a little bit, prior to the whiplash, as you mentioned, it was a pretty stable regime to begin. Obviously, you had these 37 words that spawned a regulatory regime that was maintained for about 40 years. That regulatory regime provided for non-discrimination in sports, for instance, but it allowed sex-separated teams in sports. It provided for a Title IX coordinator who was in charge of ensuring educational institutions' compliance with that law. And it provided for the prompt and equitable investigation of sex discrimination complaints. And also, it's worth mentioning that in the 1980s, the Department of Education interpreted the sex discrimination prohibition to include a prohibition of sexual harassment. So it said, if you're in an education program or activity that's federally funded, and you're being sexually harassed, then you are not receiving equal educational opportunities. You're being deprived of those opportunities. And so that is not in compliance with Title IX, and an institution has to respond to that. So let's go to 2011, where we really started to depart from some of these principles of prompt and equitable procedures and this a sexual harassment guarantee that really is about harassment as opposed to, causing offense with some speech. In 2011, the Obama administration issued a Dear Colleague letter, and that is sub-regulatory guidance. So that does not have the force and effect of law. It didn't change anything in the regulations. It was just a way of kind of threatening schools and saying, if you don't comply with this letter, we're going to find you not in compliance with Title IX. Here's how we're going to interpret our regulations and your obligations under the law.
Paul, I appreciate you calling it a Dear Colleague letter instead of jumping right to DCL, which would be a very DC thing to do since we often speak in acronyms. So when you're talking about a Dear Colleague letter, a DCL, sub-regulatory guidance, this is a letter that essentially is posted on the Department of Education website, emailed out to leaders of educational institutions.
That's right. And it's the department's interpretation, kind of non-binding interpretation of the law. It's the department saying, this is how we read the law. And so you institutions, administrators, you're on notice that this is how we read it, even if it's not necessarily based in, the most accurate reading of the text as in this case.
Okay. So this is Obama administration 2011
right.
Dear Colleague letter.
So Dear Colleague letter said it interpreted Title IX to provide for a broad standard of what constitutes sexual harassment and what would create a hostile environment that would lead the school to have to correct the harassment and respond to complaints. It swept in a lot of free speech. One-off comments by people in educational institutions would be swept into the standard of sexual harassment. And certain articles published by professors in higher education would be swept in. And, I think when we look at this, we can say that much behavior can be inappropriate and at the college level, and a college should prohibit it. But it doesn't necessarily come under a federal enforcement regime under Title IX. That's something completely different. It was not contemplated in the 37 words that we talked about dealing with federal financial assistance under Title IX. But the Office for Civil Rights, which is in charge of enforcing civil rights laws, including Title IX in the Department of Education, said that certain types of speech constituted harassment and would create a hostile environment that would make an institution out of compliance. It also mandated a lower standard of proof in grievance procedures that dealt with sexual harassment complaints. So it said that Title IX mandates a preponderance of the evidence standard of proof, which is basically a more likely than not standard. It's used in civil litigation, regular civil litigation, and it's found nowhere in the statute. And it said you can't use any higher standard than that. But, they didn't cite any. Obviously, they can't because there are 37 words in this non-discrimination guarantee. There's nothing saying that that an institution can't use a higher standard of evidence in sexual harassment grievance procedures, such as a clear and convincing evidence standard. And finally, the message of this Dear Colleague letter that I'm talking about in 2011 was basically that due process for the accused in a sexual harassment proceeding can't stand in the way of a determination of responsibility for sexual harassment for the accused. It said, you have to provide grievance procedures, but really these grievance procedures should be slanted toward a favorable outcome for the complainant who filed the complaint.
That sounds like they're saying you should presume that they're guilty if they've been accused of some kind of harassment.
Yeah, absolutely. And it definitely did not include a standard, as later regulations that we'll talk about did, of a presumption of innocence, which is really obviously the standard of our justice system and a better standard in all contexts.
So the Obama administration was not done with expanding its interpretation of Title IX. What is it that they did in 2016?
So in 2016, there was another Dear Colleague letter from the Obama administration, And for the first time in the history of Title IX, the administration interpreted sex in the Title IX non-discrimination guarantee to refer to gender identity in addition to biological sex. So discrimination on the basis of sex, according to the Obama administration in the final year of that administration, referred to discrimination on the basis of gender identity. And that took place kind of in the context of the debate over access to bathrooms and locker rooms and intimate spaces. And essentially what the administration was saying was that schools, K through 12 schools and higher education institutions, you have to provide access to bathrooms and locker rooms on the basis of gender identity. And you can't exclude people because their biological sex does not match, the way that you've separated your bathroom. And I would just say, just to go to 2017, once the Trump administration came into power, they swept away both the 2011 and 2016 Dear Colleague letters. They rescinded them. They said that their interpretation of the law was different. And so they essentially got rid of this kind of degradation of due process and this rewriting really of Title IX to apply to gender identity right off the bat in 2017. And they followed that up with notice that they were going to propose regulations under the law, which eventually came out in 2020.
So you're saying that we started with a couple of Dear Colleague letters in the Obama administration, and then those were overturned in 2017 with intention to begin a regulatory process under the Trump administration. What was the history of regulating Title IX up until that point?
Regulations had been issued. So the first regulations were issued in 1975. That framework stands today largely. And so it is basically the same framework. The Education Department has issued updates to those regulations over time. But generally, that is the same framework. In 2020, recognizing the sub-regulatory guidance kind of ping pong that was starting to occur with the Obama administration reinterpreting Title IX without any opportunity for the public to comment, without any opportunity for deliberation by the agency and in cooperation with the public. The Trump administration rightly tried to kind of shut down that sub-regulatory Dear Colleague letter-based change to Title IX with regulations that would require the department to propose the regulations to the public. They would receive thousands and thousands of comments on those regulations, on those proposals. And then eventually in 2020, they issued a final rule which amended those regulations. And those regulations related to the due process requirements of Title IX. But really, notably, they were the first regulations that recognized that Title IX prohibits sexual harassment in institutions. It defined sexual harassment according to Supreme Court precedent to be unwelcome conduct that is so severe, pervasive, and objectively offensive that it effectively denies a person equal educational opportunities.
And when you provide that list, it needs to be and, not or, for those
exactly,
things.
And that's very important because that's the standard that the Supreme Court set out in a case called DeVos versus Monroe County in the late 1990s. And the department decided that instead of having two different sexual harassment regimes in which the institution would have to respond in the litigation context, which the Supreme Court was dealing with, when you file a lawsuit against a school, and the administrative enforcement context, when the education department comes after you because you are not fulfilling your Title IX obligations, it would each institution would have to abide by a single standard of when it has to respond to sexual harassment. And the other important part of that is that it doesn't sweep in constitutionally protected speech. It's really about conduct, harassing conduct, and it has to be pervasive. So it can't just be a one-off comment by another student that offends, a person. And the regulations made clear that that degrading or overturning someone's First Amendment rights to speech is not fulfilling your Title IX responsibility. So you can't just shut down a professor who you think is saying the wrong thing and say, I'm just trying to fulfill Title IX. I mean, that's not the way it works. And obviously that shouldn't be the way it works.
Are there other topics that were addressed in this regulatory process?
I think the crowning achievement of these regulations was its due process protections that it imposed. It fleshed out what the grievance procedures had to offer to the complainant and respondent in sexual harassment procedures. So when someone files a formal complaint with the Title IX coordinator at an institution and says, I've been subject to sexual harassment by so-and-so person, before you discipline that person, you have to give them written notice, according to these regulations, of the allegations. You have to provide them with access to evidence, all of the evidence against them. You have to provide them the opportunity for a live hearing in the post-secondary context, that's in colleges and universities, and provide the right to cross-examination by an advisor to ensure that you're getting to the truth of the allegations. And then one very important thing is that they got rid of the single investigator model, which is this model that the Title IX coordinator and the investigator could also serve in the role of the decision maker in these proceedings. So it'd be basically like a police officer serving also as the judge and the jury in a criminal court case before you're sent to jail. In this case, it would be before you're expelled from an institution, before you're fired. And so obviously those roles don't match up. If you've investigated, you've developed some preconceptions about the evidence. And so the regulations say no more single investigator model. And it allowed the institutions to choose between a preponderance of the evidence standard of proof and the higher clear and convincing evidence standard, recognizing that they had to follow the grievance procedures that offered more due process to the accused, and also recognizing that the institution would have to provide the same standard for employees as it provides for students in these sexual harassment proceedings.
Okay, so Paul, once again, I haven't heard you say women's sports.
Yeah. And so that starts to come up in the next administration.
Before we get to the Biden administration, the process here, again, it's not just we write a letter and you have to follow it. The DeVos regulation was put through the process, and then there was public comment, and then the DeVos team, the Trump administration, had to go through all those comments before issuing a final regulation, right? That's how that process works.
Correct. And it took about 2 years, if I'm remembering correctly, to go through all of the comments. There were obviously, criticisms as well as support for the proposals. And what the Department of Education had to do was respond to each substantive point in those comments. And that's why it takes so long to make these rules, is that you have to address every potential problem that might arise that someone has pointed out in these regulations. And so the final regulations end up being hundreds and hundreds of pages of preamble where they respond to all the comments. And so that's really them doing their due diligence and not just kind of doing a fly-by-night. We're reinterpreting Title IX to do this. We're really going to make them have the force of law by putting them into department regulations. And so they're really part of that Title IX apparatus once you put them into the regulations.
So that process didn't get wrapped up until 2020, basically, when Trump was about to leave office, right?
About 5 years ago, almost to the day here. Yes, May 2020.
Okay. And then we have a new administration come in, and harder to overturn a regulation than a dear colleague. What did the Biden team do?
It's worth noting that obviously the 2020 regulations, they didn't regulate directly on the meaning of sex under Title IX.
Okay.
But when the Biden administration came in, it immediately issued an executive order that required federal agencies to reinterpret laws like Title IX that referred to sex to include gender identity. And so right off the bat, it essentially ordered the education department to re-regulate under Title IX to recognize that discrimination on the basis of sex includes discrimination on the basis of gender identity, which obviously in 1972 no one had in mind in these 37 words, and with the use of the term sex, that it would refer to anything contemplating one's kind of fluid gender identity, internal sense of gender. That was followed up in the education department with a very, very wide-ranging proposal of rulemaking. They dealt with sex and gender identity. The regulation also required gender identity-based access to spaces. The regulations also said that because sex includes gender identity, discrimination in sports on the basis of sex would be prohibited. And so you're prohibiting through these regulations discrimination on the basis of gender identity in sports. The department was careful to say that it didn't affect sports. They were issuing a separate rule that actually never crossed the finish line.
You say careful, I would say misleading.
I think that's fair to say. I think that obviously the administration set out its intentions with regard to gender identity-based sports competition in its filings in various court cases, including the BPJ versus West Virginia case. So we knew exactly what it meant when it's talking about non-discrimination on the basis of gender identity in sports. And it also, in its regulations, it essentially eviscerated the DeVos Education Department regulations on due process, and it redefines sexual harassment once again to sweep in a bunch of free speech. And part of the interesting nature of these regulations is that because it prohibited gender identity discrimination and it broadened the scope of sexual harassment, it made sure that if a teacher mispronounced a student or dead named a student, that teacher must be subject to discipline, or the school must respond to that. It would define that as harassment, to which the school would have to respond.
Which were policies that many school districts had in place, claiming that they had to do that under Title IX, which was not actually true because there was no Title IX requirement. School districts, I think, just wanted to do this, and so they made that claim. And so you're saying that under this Biden proposed rule, that would have made that true, that all school districts across the country would have had those policies in place.
That's exactly right. It would, as a matter of federal law, it would force school districts and institutions of higher education to accept that kind of gender ideology paradigm in their programs. And finally, it, as I said, it took away many of the due process principles. It allowed the single investigator model. It took away some of the access to evidence. It didn't require written notifications in the case of complaints of sexual harassment. So there's a lot of issues there. It was issued. The proposal was issued in 2022. It received about 250,000 comments, which is the most number of comments that any regulation. I think I can say the most that any regulation at the Education Department has ever received. And in 2024, the department issued its final rule with hardly any changes, nothing substantive involving what we've talked about. And it was immediately blocked by a number of federal district courts. It actually went up to the Supreme Court, and the Supreme Court approved the injunctions that blocked the final rule of the Biden administration, saying that especially the provisions that dealt with gender identity and with sexual harassment were, in fact, the Supreme Court said unanimously that those provisions should be blocked through a preliminary injunction. And just to think about that a unanimous Supreme Court that is often so divided on these cases said that these provisions from the regulations should be blocked, I think should give all of us some hope for the future of our jurisprudence in this area. And eventually, two courts actually vacated the rule, which basically means they wiped it off the books entirely right before the Trump administration took office in 2025. And so the Trump administration was able to say, we are going back based on these vacatures and these decisions blocking the rule. We're going to go back to enforcing the DeVos era regulations and all of the pre-existing regulations that were there. So that's our current state of affairs. And sorry for the long detour there.
Let's go through the years for this regulatory whiplash or policy ping pong: 2011, 2016, 2017, 2020, 2024, 2025. So as you were talking, I'm just thinking what life must be like for a Title IX coordinator, for the staff of a school district. You think we have 14,000 or so school districts, many of them very small. So folks at those school districts are trying to keep up with all of these changes. We have thousands of institutes of higher education. Those offices are trying to keep up and figure out where things are. You throw in lawsuits, like you said, injunctions that stop the rules along the way, adds other layers of confusion. I can understand why there would be a real need to stop the ping pong, to stop the whiplash. And I would love to hear about what DFI, Defensive Freedom Institute's proposal is to make that happen.
I totally agree. And I think you've hit the nail on the head that people don't know what their rights are in schools because they change with every presidential administration. And institutions don't know what their responsibilities to respond to discrimination and harassment are. And so DFI has proposed the Respect Title IX Act. It stands for the Respect Equality in Sports, Privacy and Education and Campus Transparency Act, because you always have to have a clever acronym when you're introducing a model law or legislation. And our aim with this is to settle once and for all these questions of what due process are students and faculty entitled to under Title IX, what is sexual harassment under Title IX, and unfortunately, we also have to settle the question of what is sex and what is male and female under Title IX, because we've seen that progressive administrations have tried to take these positions that say that gender identity is a part of sex or the same as sex in a certain way. And so you have to provide equal access to sports, to dormitories, and to private facilities like locker rooms and bathrooms on the basis of sex. So this law is really intended to end that whiplash, end those the wild swings from one administration to the other, and provide clarity and predictability for everyone involved in the education community about what Title IX requires.
If this is passed by Congress, so we're talking federal law, not state law, because some states are tackling this issue, defining male and female, protecting women's sports. But you're saying this needs to be done at the federal level. Then what happens when administrations want to change things through regulatory process?
And so what our act would do is say that the successive presidential administrations no longer have the ability to issue regulations under Title IX. They have no right to add to the Title IX structure. Our act would take much of the regulatory regime that is currently in Title IX, and we will put it in the statute. And as we know, the president doesn't have the right to unilaterally change the statute. Congress is the one that rewrites the law with presentment to the president. And so the president could not unilaterally change Title IX. And I think that in light of the Dear Colleague letters, in light of the regulations, I think we have to once and for all provide clear terms, clear definition of terms in the statutory code that define what Title IX applies to, and then that's a permanent fix to Title IX. And so we're calling on Congress. We're putting this out there to Congress and saying, look, the ping pong needs to stop. We need legislation that actually respects the rights of all students and that provides for clear responsibility to these institutions. So let's just end the whiplash that's occurred in the presidential administrations.
So DFI's Respect Act incorporates a large part of the regulatory code and law. And so when you're saying that, that's the DeVos rule that is now the law of the land, because the Biden rule is off the books due to judicial decisions. But it also addresses the definition of sex, because that was not something addressed in the DeVos rule. Any other provisions that weren't part of the DeVos rule?
Yes. In line with the definition of sex, the law would also prohibit biological males from competing in girls' and women's sports. And so if you identify a sport as a girls' soccer team or a girls' gymnastics, you can't, as a school that is federally funded, you can't allow biological males to compete in those sports. And this is very much in line with President Trump's executive orders on keeping men out of women's sports and defending women against gender ideology. Along the same lines, it would prohibit schools from allowing biological males to access girls' and women's bathrooms. And if you do provide a gender-neutral bathroom, you have to provide a private option for people. You can't force girls and women to share the same bathroom or a dorm room with a biological male in your program or activity.
Let's talk about school districts that like to keep secrets from parents. I hate this topic, but we have to address it because it's a reality out there that schools are, in some cases, aggressively socially transitioning emotionally vulnerable children and then hiding the child's new name and gender identity from the parents. How does the Respect Act address that issue?
The Respect Act, for the first time, would include a parental rights provision that says that explicitly recognizes the constitutional right of parents to direct the upbringing and education of their children. And it would say that if you are abiding by Title IX, you have to respect those rights of parents. So no more secrets from parents and claiming that Title IX prevents you from sharing that your child is going by a different name at school or that they're socially transitioning in any other way. I think that's an extremely important recognition that parents should be in charge of their kids' education. I'd also like to see further reforms throughout federal law, including in FERPA, that strengthen parents' rights to receive that information. But certainly you should not be able to use as a school Title IX as a shield for, that prevents parents from getting information about their kids.
Absolute madness that this has to be addressed in federal law, but so essential that action be taken on this. So how can people stay up to date on what's happening with the Respect Act?
We have a dedicated place on our website that has resources related to the Respect Title IX Act. It includes a brief summary of the provisions of the Act and how it would prevent the policy whiplash from continuing to occur in the future. We've included a full version of the Act on our website and an annotated version that explains some of the provisions and how they would differ from the current regime that I hope the public will find helpful, as well as lawmakers. That's on our website, dfipolicy.org. And we have a nice banner at the top of the website to ease your access to find this really important resource and statutory statutory code.
Well, Paul, thank you for your commitment to protecting Title IX and parental rights. Thank you for being a fantastic colleague, and thank you for joining Freedom to Learn.
Same to you, Jenny. Thank you so much.
Freedom to Learn is a production of the Defense of Freedom Institute. You can learn more about DFI at dfipolicy.org. If you have feedback or suggestions for future podcasts, please reach out to us at podcast@dfipolicy.org. If you enjoyed today's episode, please subscribe and leave a rating and review wherever you listen to your favorite podcasts.